Good morning, everyone. I'm Carol Egan, a partner with Cowan Gunteski, certified public accountants and business consulting firm, and co-sponsor of today's presentation. This is our fall 2016 Executive Forum, the Employment Law Quiz. Cowan Gunteski & Company is located in Tinton Falls and Toms River, New Jersey. We provide companies with value beyond accounting, innovative solutions, and consistent, exceptional service. Our services do not end with the compliance of financial statements and tax returns. We don't want the delivery of the compliance to be the end of the story. It's the beginning for us. Your CG team is comprised of industry experts who provide a personalized, consultative approach for traditional accounting and tax services, business and profitability consulting, benefit plan auditing, business valuation, forensic accounting, and litigation support. Our website is www.cgteam.com. We want to earn your trust and your business. Are you ready for the new overtime rules? They might become effective as soon as December 1st, 2016, which is fast approaching. What do you and your business have to do to get ready? What could be the financial impact to your business? This morning's presenters are Mark Kluger and Bill Healey, founding members of Kluger Healey, LLC, a law firm located in Tinton Falls and Florham Park. Their firm specializes in areas of law that impacts every business. They offer a comprehensive range of management-side employment law solutions, including human resource consulting and policy development, union avoidance strategies, and collective bargaining, and workplace training and investigation. Kluger Healey also defends businesses and managers in federal and state courts and before various administrative agencies throughout New Jersey and New York. The firm has successfully defended against the full array of claims that employees file, including discrimination, sexual harassment, whistleblower retaliation, wage and hour, and contract claims. The firm also represents businesses in matters involving trade secrets, independent contractor issues, fraud and defamation, non-competition, non-solicitation, and confidentiality agreements. Mark and Bill are here to guide us on the new overtime rules and other employment law issues. So, will you pass the employment law quiz? I welcome Mark and Bill.
Let's look at what we call some troubling statistics. There's been a 400% increase in lawsuits filed by employees over the last 20 years. 42% of employment lawsuits are against private employers with 15 to 100 employees. 20% of businesses will face an employment lawsuit with an average cost to defend of $125,000. And there's more. When employment lawsuits go to trial, and there's a couple of reasons for this, 67% of the time in state courts the employees win, and 63% of the time in federal courts they win. There's differences we can talk about later about why state court is really a better place for a plaintiff. The median judgment in cases that go to trial, the employment cases that go to trial, is $200,000. But about 25% of those cases result in a judgment that exceeds $500,000. So what does all this mean? Let me answer that for you. It means lawsuits suck. Lawsuit is not something that you want to be part of. If you have, and the problem though is not limited to lawsuits. The statistics I just gave you are about civil litigations. There's other places where employment charges or claims get filed, and that is administrative claims, the EEOC, for example. In 2015, the EEOC received 89,000 workplace discrimination charges. That's nationwide. 45% of those charges involve retaliation claims, 31% involve workplace harassment. The top three kinds of discrimination claims were race, disability, and sex or gender. And the problem's not just, but there's more. Here in New Jersey, we have the Division on Civil Rights, We have the Department of Labor, and so often, you're not dealing with employment claims in the context of a civil lawsuit or administrative charge, but you're getting hopefully what none of you have ever received, and that's a demand letter from a plaintiff's lawyer who's looking for your firstborn because somebody he thinks was wrong in the workplace. Now, we have, so what do we do about this? Well, I think we could do what I think Shakespeare suggested back in 1561, I think it is. And I think a lot of you would be very much in favor of this. We can kill all the lawyers. Now, if you want to stay out of jail, you don't want a life imprisonment, not a very good idea. Okay? So what do? You could do, instead of going to jail, instead of killing someone, you could learn. And you can learn how to prevent, and if necessary, learn how to best prevent an employment lawsuit should one come down the pipe. The key there is being proactive. Now, this is a little bit ironic. The best advice, I think, that's ever come from someone on what employers should do to how to prevent and, if necessary, how to defend an employment lawsuit comes from one of the biggest perverts in history. Google this later. Benjamin Franklin. Look it up later. He was a real diva. Benjamin Franklin told us, and you've seen this before, that an ounce of prevention is worth a pound of cure. Now, what that's all about is, and this is so important, it's about being prepared, prevention, being proactive, a little bit lucky, and you want to avoid these lawsuits. I have had, I guess it's been 24 years now that I've been defending employment litigations. And I think I have the unique perspective of having sat or stood next to the business owner when the verdict's about to come down. It is not a place you want to be. No matter how confident you might have been in the beginning of the litigation, 2-3 years in, when you can't get rid of the case, and the judge hasn't dismissed it, and the demand's insane, that moment when you're waiting for that jury to decide isn't cool. And you want to avoid that. And you avoid that by being proactive, looking to prevent, and hopefully a little bit of luck, and you won't find yourself in that spot. So that's that. Okay, so let's get down to the quiz. Mark, we have the first question here that on the...
You know, I don't know if I may have forgotten to tell you that my cousin got married at the Franklin Institute this weekend. You know, I don't know if that's. I think that might be sort of a bad omen. I'm glad I didn't know that before the wedding. Wow. I thought it was kind of a cool place for a wedding, but. And, you know, I was also thinking we could probably just start by killing most of the lawyers. You know?
Yeah, not all.
Not all.
The vast majority.
So are you ready for the changes to the FLSA? December 1st. Did I hear a yes or a no? Or a groan? Groan, yeah. Yeah, rightly so. So here's our first question. A company currently pays its secretaries $34,500 per year. Under the new FLSA regulations beginning December 1, the company will have to increase all of the secretaries' compensation. True or false, guys? Right. Because, do you know why? Because the secretaries are non-exempt employees in most instances, with the exception of, you know, real, genuine executive secretaries. I should be saying administrative assistants, I think, too, just to be politically correct these days. We ought to be politically correct. But administrative assistant secretaries are non-exempt employees, meaning that they are eligible for overtime, right? And that's based on their duties. Now, so the regulation, the change to the regulation applies to exempt employees, not non-exempt employees. So if employers are paying their secretaries below the $47,000 threshold that will be in effect as of December 1st, it's irrelevant. You can continue to pay your secretaries at this rate, or anyone else who is non-exempt. Does anyone think it makes a difference that secretaries are paid by salary as opposed to an hourly wage rate? Because often employers make the mistake believing that if they pay a salary, their secretaries are not eligible for overtime, but that's not true. They still are non-exempt based on their duties. So as a result of that, if they do work overtime, this is common. A lot of white-collar organizations pay their administrative assistants a salary. People like to know, here's your, this is what your annual salary is when you hire somebody. This is the annual salary. But the reality is, because they are non-exempt based on their duties, their responsibilities, they are. You could call them non-exempt, or you can call them hourly employees. That's what they are, based on their job responsibilities. So if they work overtime, they are eligible for overtime, anything over 40 hours a week. How do you get that? How do you get what you pay them in overtime? You take that salary number and you divide it by 2,080, which is 40 hours a week, 52 weeks. I don't do the math, I just tell you what it is. So there's an hourly rate. You would pay time and a half that hourly rate for any administrative assistant who worked more than 40 hours in a work week. Everyone good with that? All right, so that's the threshold of our discussion about the new regulations. They don't apply to your current non-exempt employees. The issue is the exempt employees. So let's go to the next question. And under the new I'm going to say it right once today, FLSA regulations effective December 1, 2016, employers must pay employees a weekly salary of at least $913 to avoid having to pay overtime compensation. True, false, or depends? It depends. What does it depend on?
Their duties.
It depends on, right. Okay, so it depends on a couple of things, right? It depends on, that is going to be true for some employees. The classic example that these regulations apply to are your managerial employees who are making, less than $47,476 a year. That's what you need to focus on. Managerial employees, so employees whose duties are exempt. So you're currently not paying them overtime, they're getting a salary, they are exempt by law, and they're not eligible for overtime. A lot of employers are really focusing on their mid-level managers or lower-level managers who are, the guts of the organization. They're the people who are there, all the time, 50 hours a week. I think when they were talking about this legislation in public, a lot of the pundits who were supporting this change were talking about, the fast food restaurant managers. That was really that was sort of their the poster child for the reason for the change. So they were saying, hey, the McDonald's manager works 60 hours a week and he's making $30,000 a year. Okay, that's what these regulations were designed to change. So right now, okay, come December 1st, if that McDonald's manager is still making $30,000 a year and working 60 hours a week, he's going to be eligible for 20 hours a week overtime. Okay, so employers have to make a decision by December 1st what they're going to do with those managerial employees, those exempt employees who are making less than what's going to be the new threshold. The new threshold will be $47,476 a year, or $913 a week. And it's going to be, an economic decision. It's going to be what, let's say, you have a manager who currently works 50 hours a week and is making $30,000 a year. You can decide to leave them where they are at $30,000 a year and pay 10 hours a week of overtime, right? So they, come December 1st, will be a non-exempt employee, okay? They can keep the exact same duties. There's two pieces to this, right? Duties and salary, right? So they can keep the exact same job responsibilities, but they will become non-exempt if you keep them at their current salary at $30,000, okay? But you're going to be paying, recognizing what they're typically doing in terms of overtime. Now you can also cut that overtime and say, hey, you can't work more than 40 hours a week going forward. But assuming you need them to, you can simply pay the 10 hours a week of overtime, and it's a matter of dollars and cents. It's a matter of figuring out, is it worth for you to pay 10 hours a week of overtime or bump their salary up, in the case that I'm using, by $17,000? So that's really that's sort of the guts, as simple as I can get it, because that's what I need to do so I understand it. And that's how it's going to work. Any questions? That's it? No questions about the change? Great. That's so good. We got a good group. They all understand it. So let's move on to something more interesting. Before interviewing an employee, you do what you always do. You review all the applicants' postings on Facebook, Twitter, and whatever else you can find. You find that she's a big Trump supporter. During the interview, you ask about her politics. You may reject the applicant without recourse because you support Hillary Clinton. Is that true or false? What do you think?
It happens.
I'm sure it does. So let's start at the beginning. True or false? The answer is true. You can do that. People's political views, this may be somewhat counterintuitive to you guys, but people's political views are not protected. If you're a Hillary supporter or a Trump supporter, and the boss is the other, you could be out of luck if you want to talk about it out loud at work. That's a personal decision. So let's first start with, or let's go back to social media. You allowed to look at Facebook, Twitter, and whatever else is online? Sure. If it's public, you can look at it. So kids today are getting pretty clever about all this, right? Changing Facebook names and stuff when they apply for jobs or blocking everybody. But some of them are not as clever as they think, and there's still an awful lot out there, right? So, boy, those spring break pictures are very telling, aren't they? So you can learn an awful lot, and if one of the things you learn in looking is politics, well, then, and if you feel very strongly about your candidate, then you have an opportunity to make a decision as to whether you want somebody from the other camp working for you. But can anyone think of any pitfalls to looking at social media, any downsides? Probably only Bill and I think of the downsides, because that's how we're wired. There's some possible landmines in social media that could be problematic. So you go on somebody's Facebook page and you start roaming around just to see what you can see, and you discover something about their sexual orientation, okay? And then you interview them. And somehow, you know, you're not as disciplined as you think you are, and something slips out that shouldn't. Okay, you ask a question, you make a statement, you make a comment, you say something that you're assuming based on what you learned on social media, and then you decide for legitimate, non-discriminatory reasons not to hire that person. And their radar is up, and they're saying, I'm qualified for that job, why didn't I get it? Aha! They looked at my social media and they saw that I was a member of this organization, or I did this when I was in college, and that's why I didn't get hired. And then you're going to get the discrimination case, failure to hire. Sometimes there are things in social media that you don't want to see, that you don't want to know, at least not until after the initial interview, after you've had the face-to-face meeting. And then if you want to do your background checking and things like that. But sometimes, like I said, and it's just human nature. Sometimes, we just get something in the back of our head from looking at social media. We have so much, sensory overload these days that we don't know where the information is necessarily coming from, and it's your head. So we've had it happen, and we know about these situations, and there are failure to hire cases. People get sued all the time. And employers get set up today, too. Keep in mind, sometimes if you have an applicant, there are a lot of advocacy groups who will send plants in to interview for jobs. A lot of the disability organizations will do that. They will send somebody in intentionally with a disability to apply for a job to see how the employer handles it. Whether they talk about reasonable accommodation as part of the job. So if somebody comes in with an obvious disability, be careful, but don't be surprised if you're being set up. So it's just important to be really careful about what you know and when you know it. Let's talk about one other thing, politics at work. Anyone think it's a good idea to talk about politics at work? I got to tell you, do you think you can tell your employees we're having a gag order on politics at work? No. Well, you can. You can make the rules. You can say, this is a topic that we are not talking about here, okay? And I got to tell you, if there was ever a time in our lives when that ought to happen, this is it. The degree of divisiveness that this is causing in the workplace can really cause all of us a lot of headaches. And I have been telling clients, and I know Bill has as well, let's just counsel not to bring this up. Go ahead.
What about like out in the parking lot type of thing before they get into the office or building? Where they happen to be walking in together and then they wind up in a fight?
Yeah, they can, yeah, brawling in the parking lot over politics. I mean, it can happen.
The same,
Well, it is. I mean, the idea, I think, is to the extent you can, put a gag on it. Just say, guys, not at work, and work includes the parking lot. I mean, I just think it's a really healthy decision to make these days. People will say, I have a First Amendment right to talk whatever I want. You're not the government, okay? So the First Amendment doesn't apply to the rules you set, okay? So you can just say, guys, at work, we're not talking about it. Why? Because it's a big distraction. It's a huge distraction. I mean, you could think about it in any other time of life, it's going to be a big distraction to talk about politics at work, but this, is going to lead to that, right? This is going to lead to really strong bad feelings among people, and it's just not worth it. And so you absolutely can tell your employees, we're not talking about politics this fall at work, okay? You can go rant and rave to your friends at home or online or whatever you want to do, but keep it out of the office. And I think it's a really good piece of advice for all of you to just do what you can to put a gag on it at work. Because if you think about some of the issues that can come up, right? Somebody doesn't want to vote for Hillary. Well, there are a lot of people who are going to say, oh, you don't want to vote for Hillary? You don't like women. You're against women. You're discriminating against women. There are people, obviously, Trump has made enough statements to alienate just about every protected group that there is. And so somebody who's supporting him is likely to become the target for accusations of, I don't know, you name the ism, you can be accused of it. So I think it's an interesting time and a dangerous time. So, any questions about that? Yeah.
I just want to make sure I heard you correctly. Just a minute, please. I'm sorry to interrupt. If you can just let Taylor get the microphone to you so everybody can hear you.
Yeah, I just wanted to make sure I heard you correctly that you talking about politics at work, if an employee brings it up, is grounds for the employer can dismiss them?
No, I didn't say you could. I mean,
or at the interview process, not somebody.
Oh, in the interview process?
Yeah, I thought I heard you say that politics is a protected.
It's not a protected.
Not a protected topic.
Yeah, so you can make a decision if you're the president of the company. You can say anyone who's supporting Trump, I don't want him here. So you go on social media and you see that that's a Trump supporter, you can make a decision before they come in for the interview or after you interview them to say, I'm not hiring someone because of their political affiliation.
Counterintuitive, like you.
Yeah, it is counterintuitive. I mean, it's different from, because we're talking about a political candidate as opposed to if you see that they are a member of the NAACP, for example, that would be a dangerous decision to make based on that. Because of a potential race discrimination case. But if your decision was based purely on they're supporting this candidate, I can't stand that candidate, I don't want them here. That's perfectly legal. You agree, Bill?
Totally.
Okay, good. That's helpful, I know, right? Hey, you never know. Yeah, well, listen.
Let's go to number 4.
All right.
A female manager tells a male subordinate that he has nice buns. If a female manager regularly tells a male subordinate that he has nice buns, it is probably not sexual harassment. However, if a male manager often made the same remark to a female who reports to him, it could be sexual harassment. Let me handle it this way. I'm going to ask someone I know. Ken. Yeah. If I polled the guys in the room and I said, if your female boss comes to you and makes that comment to you, you have a nice, I'm not going to say bunch, but say, Ken, you got a nice ass.
Thank you.
Is that you just made my point. Is it a life, job-altering event that you can't work with this person anymore because she said that to you? Probably not.
Probably not the first couple times, but if it continued, it could be, it could become an issue.
And I'm a little hurt that you've never said it to me.
We've asked this question now probably 1,000 times. I've seen guys high five over this. It depends on what she looks like. Guys generally don't care or they laugh. It's not a big deal. You flip it around and you say to the female, if your male boss said this to you, whole different ballgame, right? They don't want the boss knowing they have a rear end. And it's just not cool. And then if you ask the guys, if you say, if your wife, your daughter, your girlfriend, your mother, your aunt, if they came home from work and said, my boss said this to me, the guy's got a very different view of that. It's not cool anymore. Everybody agree with that?
Yes.
The point is that we're talking about the exact same comment, nice buns, and you had two potentially different, well, you clearly had two different reactions to that comment. The general male reaction and the general female reaction. Everybody, we're all in agreement on that? So what does the law do about that? There's a double standard out there. The same conduct is being viewed differently based on gender. So can it be the case then that in a sexual harassment case, that the gender of the victim, the the recipient of this comment, that depending on the gender of the victim, you can have a different result where one is sexual harassment, one is not? Does that make any sense? Does that seem fair? No. But that's the way it is. Okay? The jury instructions in these cases take into consideration the gender of the victim. Okay? So if you're going to have a situation where someone is saying, and again, this is not realistic, there's going to be much more going on than just this one comment. But if the jury is going to be able to decide, remember, the jury is presumably made up of male and females, would a reasonable male feel that their working environment has been altered because they heard this comment? If Ken is the reasonable male, and he is, because I've heard that reaction a million times, it may not be considered reasonable for it to be sexual harassment. Flip it around, and if I ask Danielle that question, we could have a very different result, and the law accepts that because the law reflects that double standard. Everybody get that? A little strange, that's the way it works. Chris?
All right, so you reach a point in time and age as male that you welcome those comments. In effect, you encourage them. But my question is, how do you explain the difference in your employee handbook? You can't, in your handbook, I would think, say, well, you guys can have at it, but don't do the same thing to the ladies.
Thank you for bringing that up.
You're welcome.
That is an excellent point.
Thank you.
We are talking about whether something is going to rise to the level where the law is recognizing it as sexual harassment. Telling someone that you have nice buns, or more graphic, nice ass at work is wrong and something that you can be terminated for without regard to whether it's going to rise to the level of something the law recognizes as illegal. So it is an improper comment for which you can be disciplined or worse, terminated for. But it's a question here of, is it going to meet the legal standard of being, where the law recognizes it as a sexual harassment?
So, Bill, is the rule of thumb be consistent?
Rule of thumb is not say stupid things.
I'll take that as a compliment.
You can't be making, out of your mind, be making assessments. Should I say this to her, but not to her? If you're even going down that road, you're kind of, all right? So I wouldn't be going anywhere near that.
So Bill, in your handbook then, would you have something in there that says, in the handbook, would you have something that says, or as the employer, I have the prerogative of interpreting some of these things to fit the work environment that we want to create, as, forget the law, but something like this example said, we interpret it as inappropriate male guy, and therefore you're out.
I don't know that I would get that detailed in a handbook. We have a very different school of thought on handbooks than a lot of employment law. We think less is more. So you don't want to give a body of law and statements in there that can be relied upon. You need a lot of wiggle room and discretion. So I think, in a handbook, if it's combined with training and you're giving people a clue about what is and what isn't sexual harassment, because there's so many facts and context depending on where you work, different comments in one employment context can be appropriate but not in others. So you need I don't know that I'd get that potentially detailed.
Does the same apply for quid pro quo? So if she says instead, I want you to wear those black pants because they make your buns look nice, is that still applied that way?
Well, it's a quid pro quo would be a whole different animal. I mean, that's if the supervisor, someone with supervisory authority is really propositioning someone either to give, take away, some potential job benefits. I mean, that's a whole different ballgame. That's slam dunk stuff when it comes to sexual harassment. This is really the nature of hostile work. Chris?
Bill, let me throw you a softball. The rule is that anybody here who owns a business, stop being lawyers. Get Bill or Mark's phone number and call them, because that's when you get your little what's in a jam. Call them because they don't bill you. I have personal experience. They work for free.
Wait, who said that?
Or they'll work for food, one or the other. But trust me, most of the clients that I have spend too much time trying to be lawyers.
And then one thing you got to be very careful about is that, and then you can get paranoid with this, especially if any of you have been in a litigation. What you say, what your managers say, will be admissions that will come back and crush you later. So you do not want your supervisor, who's uninformed and maybe well-intentioned, saying, we got to do something, this is sexual harassment, that she's been violated, those things. He may be wrong. It may be something that's just an improper comment, but it's not rising to the level of something the law is going to recognize as illegal. So you got to be very, very careful. Less is more. That is such a lesson.
And just to your point, while you're working your way back up there to grab that question, we do want the 5-minute phone conversation. You're 100% right, because the 5 minutes that you spend on the phone with us will save so much. Anyone who's ever been in litigation knows what it's like and how time-consuming and expensive it can be. And if you can avoid it by spending 5 minutes talking to one of us, that's what we prefer. We'd rather keep you out of trouble. And even if you think it's a dopey question, believe me, we've heard plenty of them. So there really is no dopey question when it comes to diffusing a potential employment litigation. So call us.
Would that same concept apply if there was actual physical touching, back rub, whatever? Would the same thing apply?
Yeah, you have, absolutely. I mean, it's all, whether it's sexually charged conduct, whatever form it's taking. I mean, this is an offensive remark that's being made. But yeah, clearly, if it's the back rub, it's the touching, something that you reasonable people would view as not being appropriate for work.
So along with Bill's comment, don't make stupid comments, don't touch your employees, okay? Sorry.
Any questions on that? All right. Number 5.
Okay, you need a salesperson, and you receive over 100 resumes. That happens a lot today, especially with online, right? To reduce the number of candidates, you may eliminate those individuals who appear to have been unemployed the longest. What do you think? Okay, so this was really this was a problem, not as much right now as it was 2, 3, 4 years ago. After 2009, this became a pretty hot issue because you may recall the federal government was extending unemployment benefits for long periods of time because there were many long-term unemployed, right? So it became difficult for hiring managers to weed through the literally hundreds of resumes they would get for almost every position, including people who were wildly overqualified, right? So this was a big problem. And so the question was, some employers started saying, in their advertising, the unemployed need not apply. Okay, that was very, very common. I don't know if any of you have seen that or done it, but it was very common. Okay, so some states, and New Jersey was among them, in 2011 passed a law that prohibited that phrase from any job advertising. The unemployed need not apply. So in 2011, New Jersey passed a law and said, can't do it, can't put that in your ads or job postings in any way. You can't imply it and you can't say it. Okay, that was in 2011. In 2014, both houses of the New Jersey legislature passed a law that said that it was discriminatory to do this. It was discrimination to weed out the unemployed from consideration. But Governor Christie vetoed that law, and both houses didn't have enough support to override it. So the answer to this is true. You can eliminate the unemployed. It's just funny. So everyone's starting to write when I said 2014 law, and now they're just going like this. All right. So, okay. Sorry about that little game. Okay.
I have a question.
Yeah, sure.
Recently, we hired someone to put in signs and file permits, but in questioning him, I asked a question. I said, in your last job, how long did you have that job? The job before that? And in the last 5 years, what jobs did you have and how long were you there? It sort of gave me a history of, is this guy longevity? Or,
right.
And believe it or not, the guy was 1 year, then 3 months, then He worked for me 1 week, the next week, well, I have to fix my car, oh, I got this, and then he never showed up.
Yep.
So you can ask those questions.
Absolutely, and that's a great
That gives me a
methodology.
little background on the type of guy he was.
Yeah.
He followed through.
yeah, exactly. Yeah, he proved to be consistently inconsistent, right?
All right, let's go to number 6. A race discrimination case is filed against your company. The case goes to trial after several years of contentious litigation. The jury finds discrimination, but only awards $25,000 in damages to the employee. Her attorney applies for a counsel fee award, which total $250,000. Your company could face a judgment of $300,000. The math make sense? No. What do you think? The answer is true, but how does that make any sense? Anyone have an idea? Well, this is what makes this, and this is often the news that I give when we are handling a new discrimination, harassment, or retaliation claim. The following is often what jolts employers more than anything else. These statutes, the Law Against Discrimination, Title VII, the Whistleblower Statute, they are all what's called fee-shifting statutes. But it's worse than that, as I'll explain. These cases, and they sound very cynical, are so much more about the plaintiff's lawyer than they are about the plaintiff and about the employee. It's about the lawyer, because it's a money grab. You have, the jury comes back and they say, all right, something happened, there was race discrimination, but so she's working, maybe it wasn't so bad, it didn't last so long, we'll kick her $25,000. But the lawyer, who hasn't been getting paid along the way, the plaintiff's lawyer, he spent $250,000 of his time in fees and expenses over the last 3 years fighting, trying to prosecute her claim. Well, that judgment would be, what's the math, $275,000. So where does the other $25,000 come from? Anybody have a clue?
Interest or double jeopardy?
I'm sorry?
Double jeopardy?
No, it's not interest. It's called a multiplier. It's a reward. Not available all the time. But a judge in New Jersey has discretion to not only award, and look who's winning here. The plaintiff got $25,000, the lawyer gets $250,000. And that lawyer can now apply for what's called a multiplier in New Jersey as a reward that they get for these kinds of things. Was he jerked around over the last 3 years by the defense lawyer? Where the defense lawyer refused to discuss settlement? Did he make new law? You know, these are things that courts are going to look at and say, we're going to give you your time. Right? You got her $25,000. You proved race discrimination, which is an awful thing that we want stopped. So we're going to give you, for that, which you didn't get paid along the way, you're going to get $250,000, but you really had a hard time getting that result. So we're going to give you a 10% multiplier on top of that. And the lawyer walks away with, what's the math, $275,000, the client gets $25,000. That's fee shifting, and it happens, this is the nightmare scenario where the case you've been unable to get it dismissed, unable to get it resolved, the jury doesn't go in your favor, and now you're facing the fee application, and you better hope that the judge doesn't, on top of everything, award a multiplier. The way you deal with avoiding the multiplier, and this is not weakness, it's just being smart and practical. And clients generally, especially if you're reading them for the first time, don't really like this. You have to say to them, I will be your gladiator. Right? I'm here to be your gladiator. But we've got to be practical here and also consider settlement. And a lot of, I don't want to settle. You don't believe my case. I believe in your case, but we need to be practical here, because if we don't entertain the possibility of settlement, that will be remembered, and that'll be jammed down your throat 3 years from then with the multiplier. So it's really got to be very careful with this stuff. As much as the case is defensible, you've got to be practical, and you got to look for an out, a reasonable out, if it's available.
How does that differ from loser pays, which I thought was allowable, and does it go the other way?
This is going to drive you nuts. Theoretically, it goes your way. It goes the other way. The statute will read that your fees shift, right? So the prevailing party is entitled to it doesn't say shall. The prevailing party may get a fee award. Now, good luck. There isn't a case out there where the defense wins, and we're making a successful fee award on on the plaintiffs that have had to work for 2 years, it's never going to happen. So as a practical matter, although the statute is reciprocal, it's not. And this is why you have EPL coverage. This is why you have that stuff to protect against this, because it is not about the plaintiff. It's about the plaintiff's lawyer and his ever-accumulating fees. That's the nasty game that's going on. So yeah, it is reciprocal, but be naive to count on it. Any other questions on that?
Yes. Wouldn't the attorneys get part of that $25,000 also?
They could, depending on the fee agreement between the plaintiffs and plaintiff's lawyer, yes. Now, understand this, I mean, if the case is getting resolved early, or the case is, this is a post-trial fee award scenario. You're deep into the case at this point. If the case is getting resolved at mediation, or after a deposition, or just by the exchange of demand letters, there's not fee award. Right, the employer's paying 20 grand to get rid of the case. How that gets chopped up between the plaintiff and the lawyer, we may know, but we don't really care. But you're not going to be facing a fee award down the road. This is the post-trial nasty application where all hell's broken loose. Okay? Any other questions about that?
Starts making Shakespeare look a lot more clairvoyant than we thought, huh?
And by the way, this is Jersey, this is federal, this is everywhere. Number 7.
All right, so you interview a great candidate to be your new CFO, and you make him a conditional offer, conditioned on background check. I hope you're doing that. And in the background check, the results turn up a conviction for possession of cocaine from 1984. I just chose that year because that's when I graduated from college. Just a coincidence. He served 9 months in jail. You can tell him that you are withdrawing the conditional offer based on his drug possession conviction without incurring any liability. What do you think? Why do you think it's false? You got the microphone right there.
Isn't there a time limit for federal convictions? I think, is it 7 years?
Well, I'm glad you raised that. There is a mythical time limit about 7 years. 7 years has always been what background check companies used as a litmus test as to how far back they will go. But it was purely arbitrary and not required by law in any manner. So background checks can go back, 100 years if as long as you pay the fee, the background check can go back to, date of birth. So, any other thoughts about this? What do you think?
BFOQ?
Right. So, BFOQ is bona fide what is it? BFOQ, occupational qualification. Thank you. I'm really bad. FLSA. Right. Got it. All right. So, bona fide occupational qualification means, is it relevant to the job? And so this area of the law has been evolving rapidly in the last few years based on a number of things. First of all, do you know what ban the box is? Ban the box in New Jersey and in many other states now says you cannot ask about criminal convictions on an employment application. So if any of you have employment applications that ask about criminal convictions, run home and get it out there. That law has been in effect several years now in New Jersey. You cannot ask about criminal convictions. You haven't been able to ask about arrest records for a really long time. The reason is because the Equal Employment Opportunity Commission says arrests are don't necessarily result in convictions. Minority groups are arrested at a much higher rate than non-minority groups, and as a result, arrests cannot be asked about. Yes, sir.
I apologize. I don't mean to be jumping the gun, but does this mean that would imply a felony conviction? So if you have a felony conviction, regardless of the time frames, I can't discriminate against that?
I'm getting there. Hang on. Yeah, I'm going to get to that. That is the ultimate important question, right? So we'll start with ban the box. can't ask about it in advance. You can ask about criminal convictions after you've had an initial interview. Okay, so that's the law in New Jersey. Okay, so once you get past the initial screening, then you can start asking about convictions. Yep.
Say initial interview is like the first interview, but now your process calls for it to come back for 2 or 3 or 4 more.
Right.
So you, after the first one, you can get into this, or you have to wait
yes,
till you
you
finish
can get
all the
into it after
convictions?
the initial interview, and that includes like a phone screen too. So the regulations were pretty clear about that. That if you even if you just do a phone screen interview, preliminary before you even have them come in, once you get past that point, then you can ask about criminal convictions. Okay, so that's step 1. So step 2, you do the background check because you're interested in this candidate. You want him. He's perfect, okay? And I'm going to answer both of your questions at the same time in terms of qualifications. Okay, the EEOC has taken the position, Equal Employment Opportunity Commission has taken the position that it would be discriminatory not to hire a person based on a criminal conviction if there was not a nexus between the nature of the crime and the job duties. Okay, so it was not unintentional that this is a CFO and a cocaine conviction, because if it was a CFO and it was a bank fraud conviction, it was an embezzlement conviction, there's your nexus between the jobs, right? And if you said, I can't have a guy who was convicted of embezzlement taking care of my books, that's pretty easy to figure out, right? And even the EEOC wouldn't challenge that, except, okay, and I think one of you raised this, except 1984, okay, 2016. One of the so there are 2 variables that the EEOC is focused on, and they have been suing employers on these cases. So that's where this is all coming from. The EEOC has really made it a concerted effort to sue employers for not hiring ex-cons, okay, for lots of different types of jobs. And they're going to say 2 things. 1, what's the connection between his qualifications as a chief financial officer and the fact that in 1984 he was arrested for possession of cocaine? I made it possession, not sale, okay, possession of cocaine, and so many years ago, which is your point, right? So many years ago. So from 1984 till 2016, he doesn't have a criminal record. Doesn't that mean he's cleaned up his act? Why would you deny him a job because in 1984 he had a drug conviction, okay? And this is I can't give you a straight answer because it's a gray area. This is a risk. This is absolutely a risk for an employer. I mean, I used to say all the time to employers, felony conviction, throw it in the garbage. Throw the candidate in the garbage. Don't do it, okay? Can't do that anymore. Now we've got to do an analysis. What's the connection? Can you hire a guy with a cocaine conviction to sweep the floor? That's the EEOC is going to say, if you turn that guy down, because in 1984 he was convicted of cocaine possession, you got a problem. That's illegal. It's discrimination. So this is a really dangerous area for employers, and the EEOC has really used a lot of enforcement mechanisms to stay on top of it. Yes, sir.
If you're hiring for, say, a driving position where he's got to have a CDL and be drug tested, is there a nexus there? That's reasonable, right?
Absolutely.
Okay.
And those kind of things, in regulated industries and in regulated job positions, it's far easier. But you have to be careful what you ask. So, for example, you've got to ask questions like, are you qualified to do this? As opposed to, has your license been suspended, right? Or have you ever lost your license? You've got to say, are you qualified to drive a truck? So the last thing I want to mention, because this is a pretty complex area, is once you get that information, okay, you see that they've got a conviction. There is a 2-step process under the Fair Credit Reporting Act before you can withdraw your conditional offer. The first is you have to send a pre-adverse action notice under the Fair Credit Reporting Act telling the employee, or the candidate rather, that you are considering not hiring them based on the information you got in the background check. Together with that pre-adverse action notice, you have to identify the third party that you used to get the information. So if you used Infomart or one of those services, you have to say, this is the company, this is their name and address that we used, and you have to attach a Your Rights Under the Fair Credit Reporting Act notice, which is published by the government, and it tells the candidate what their rights are in regard to this. They have the right then, over a short period of time, the law doesn't tell us how long that period of time is. I always tell employers use 5 days. 5 days to get back to us with any exculpatory information, like that wasn't me. That's the best exculpatory information, right? Wrong guy. It does happen, okay, especially with people with common names, okay? Anything you want to tell us that might change our mind, okay? After those 5 days go, if you don't hear from them or you're not satisfied with their answer, then you have to send an adverse action notice saying exactly the same thing. Based on the background check, we're not hiring you. Done. But you have to do those things, and in the last 6 months, the government has been filing cases against employers who are not following the Fair Credit Reporting Act in this process as well. That's been another new initiative to raise money.
Okay, let's look at number 8. This is a whistleblower, or the statute in New Jersey is the Conscientious Employee Protection Act question. An employee sends you an email expressing his belief that your website is misleading because it grossly exaggerates the company's expertise. It can easily be shown that that's wrong. You fire him for absenteeism a few weeks later. He claims retaliation for having reported potential consumer fraud and sues the company and you. His claim is frivolous because your website is accurate. What do you all think? It's false, because whether or not he is correct or not is not the test. He is completely wrong. Your website is spot on. He's wrong. Assume that can be shown really easy. That's even though he's wrong. What the courts are going to look for is did he have a reasonable belief that the website wasn't accurate? That is generally what is known as a fact issue. That means you're going to trial on that. Okay, very fuzzy, is it reasonable? That is something that is classic stuff for a jury to decide. So here you have, so again, it's not, even though it can be shown that he's dead wrong, as long as it's a reasonable belief, he's got a foot in the door to get this case to a trial. Now, I put a couple things in here that I just want to emphasize. You know, you can fire him for absenteeism. You better be sure that you have the documentation to back up this termination, especially if it's close in time between when he first complained of the accuracy of the website and when you fired him. The chronology is so critical in these retaliation claims. Did you set, was the paper trail as to his absenteeism in the works before he first complained about the website? If it is, it could be a very easy case to defend. If it's a non-existent paper trail, or you only put it together after he complained about the website, you're going to have a problem. The other thing I put here is it says sues the company and you. In a whistleblower case, the supervisor can be a defendant. Now that's in contrast to, and getting a little off track, but in Title VII in federal court, individual supervisors, the business owners individually cannot be defendants. It's a quick motion to get you out of the case. In New Jersey, in a whistleblower case, the supervisor can be a defendant. And also in New Jersey, on the law against discrimination, individuals can be defendants. So you have this is a red-hot area of law right now with these whistleblower claims. And they can be difficult to defend, in my view, if the chronology is tight between when they complain and when the adverse action occurred. And if they're easily defended, I can show, well, the reason when we fired him, he got paper trail and it was in the works before he first complained. That's the crux of how you really defend.
We have more questions. We can go a little further.
I think you probably would want to elongate the process, right? Like, it's just because you think you would win in court doesn't mean you want to go to court, right? I mean, like, even if you had, like, what you felt was a decent case, like, I still would probably, wouldn't you say you'd want to wait maybe a few more months of maybe an extra absenteeism that you can document?
Absolutely. I provide that advice all the time, where the employer has had it, they want him out, they want to fire. And I'm like, can we just, if he's that much of a knucklehead, he's going to be absent again, let's get a couple more under our belt. You waited this long, let's wait another month to get some distance from when you complained. And that's just the positioning you do. That's the preventative stuff we were talking about at the beginning. That if you just give yourself that time, you can put yourself on a whole different plane than firing him the day after he complains. That's when these cases are problematic. That's spot on. Any other questions? Number 9.
An employee has worked for your company, which has 52 employees for 3 months, requests leave to take care of a seriously ill family member. Do you have to provide them with unpaid leave for 12 weeks and a comparable job when they return? I see an adamant head shake. No. The answer is no, because the Family and Medical Leave Act doesn't apply. It would apply to an employer with 52 employees, but it doesn't apply to an employee who's only been with you for 3 months. They have to have been with you for 12 months and worked 1,250 hours in the preceding 12 months. And for the New Jersey Family Leave Act to apply, they will have had to have worked for you for the same period of time, and they will only have, for the same number of months, but will only have to have worked for you for 1,000 hours in the preceding 12 months. But, little caveat to this, as there are to all of these, keep in mind now in New Jersey we have 13 cities that have paid family leave requirements, okay? Morristown just became the 13th a few weeks ago. So there are 13 cities in New Jersey that if you have employees there, you are required to give paid time off. It's called paid sick leave, but it doesn't just apply to the employee's own serious health conditions. It applies to taking care of family members. So it's important to know if you have those obligations. There's also the New Jersey Family Leave Insurance Act, which you may be aware of. That's everyone has a little payroll deduction that goes into a fund for that. That is not time off, okay? But it would apply to this employee that I'm describing, that's described here, okay? Because you don't have to have worked for 12 months for it to apply, okay? But that is compensation to take time off to care for a seriously ill family member, but it is not protected leave time. So it's important to understand that distinction. The employee is allowed to tap into that fund, but only, but you have no obligation to give them time off to do it. And the law explicitly says that if somebody takes that money, they apply to the New Jersey Department of Labor for New Jersey Family Leave Insurance, okay, you are free to terminate them if they don't have time off, and there are no retaliation claims allowed. So it's the only statute under New Jersey employment law that says explicitly the employee does not have the right to sue you for terminating them while they're collecting New Jersey Family Leave Insurance. We had to give you some good news today, right? Okay, manager has a heart attack. That's not good news. You have over 50 employees, so we're talking about family medical leave, and she's eligible for family leave, okay? Her doctor states she'll be out for 2 months. You have a senior employee who can run the department for the 8 weeks that she's going to be out. Near the end of the 8 weeks, a doctor sends you another note, and it says the manager can't return for another 8 weeks. Because the family leave allows only 12 weeks of unpaid leave, job protected, you advertise for a new manager, and at the end of the 12th week, you terminate the manager who's out on leave. Is that okay? Why not?
Put them into a different job. We got the thing.
Somebody say it out loud.
Accommodation.
Right. So the Americans with Disabilities Act now has reared its ugly head once again in our jurisprudence, and the courts have now said that even though you thought that all you had was 12 weeks of job protection, the Americans with Disabilities Act, which says that you have to provide a reasonable accommodation for employees who have disabilities, may include extending the leave, extending the paid time off. An accommodation could mean extra time off. It wasn't always like that. That was never part of the jurisprudence under Americans with Disabilities Act, but only in the last few years, the courts have started to say, the Department of Labor has pushed it, that Americans with Disabilities Act, reasonable accommodation could mean more time off. So if the doctor's note says she needs another 8 weeks off, 8 weeks might be a reasonable accommodation. And the employer then has the burden of demonstrating that it would be a hardship to give another 8 weeks off. How do you prove hardship? It's not so easy, especially if you have a senior employee who's been running the department for 8 weeks already. The answer would be, well, why can't you have them run it for another 8 weeks? and what's the downside. And it's in order to deal with this problem, because what ends up happening, and this is a dilemma that Bill and I find ourselves in a lot in giving advice on this, when is enough time to create a hardship? In other words, after that 8 weeks, what if the doctor's note says it's another 4 weeks, and then another 3 weeks? And many employers find themselves in this situation, and they call us and they say, when can we end this? Okay, because the uncertainty is crazy, and the answer is we don't know. It's really a judgment call as to when we can say it's a hardship. So the answer is, and we've been coming as we start seeing the cases rolling out, we're becoming a little more adept at figuring out how you have to demonstrate a hardship. And the main way you demonstrate a hardship is money, cost. What is it costing us to run without this employee? Because remember, after 12 weeks, you don't have to continue their health insurance. So you can put them on COBRA after 12 weeks, okay, so you're no longer paying health insurance costs. So it's not really costing you anything to have that person out there. What it is doing is creating uncertainty within your department, and maybe your senior employee isn't as good as, you know, a manager, so maybe you do need to hire someone, but you're going to have to demonstrate what it's costing you, what are your losses, and that involves being proactive from the beginning of the leave. Any questions about that? Okay.
All right, let me do number 11. We're running close to the end of the time here. If we don't get, we're obviously not going to get to all the questions. We want to talk about it afterwards. Happy to do so. But let's look at number 11. You establish a policy prohibiting employees from discussing their salaries with coworkers. A loyal employee shows you a Facebook discussion in which some employees discuss their salaries and refer to you as a cheap-ass boss. You can safely fire those employees for violating your policy.
Not anymore.
Why are you right?
It just changed. I forget recently where they changed where you can't fire them for discussing pay practice.
And it's a little bit of I think, a very unusual reason why Don's right. And that is, you know, the statute that they rely upon for that is the National Labor Relations Act. That's generally, you think of that as for unions, not for employers that do not have a union. Okay? So here, what the root of this is that the NLRA, the National Labor Relations Act, deals with whether employees are engaged in what they call concerted activity. So if employees are talking about the terms and conditions of their employment on Facebook or wherever, that's a protected activity that the National Labor Relations Board will put an end to. Okay, they want to foster that. So if you are, kind of funny examples, if you're going to go on Facebook and say the boss is a jerk, that's not protected. But if you're going to say the boss is a jerk because he's not paying us fairly, that's concerted activity that the National Labor Relations Act protects. Everybody get that? So it was a bit of a surprise when you're finding out, you know, we don't have a union. We don't have to worry about the NLRA. Yes, you do, because in today's day and age, with if somebody's making comment on their web, on their Twitter, on their whatever, and it's about, they can tie it to a terms and condition of employment, that's protected activity. Any questions about that? No, I guess we're near the end of the time. I mean, is there any particular, I know you had the quiz in front of you as you were, before we got started. Are there any particular questions you'd like us to go over now as a group, or?
I have a question that's really not one of these, but when you fire someone for stealing and the employee's new boss calls you up and asks you questions, what we normally do is we just say we only can discuss how long the employment was. Is that good enough?
That is, well, yeah, that is. You are not obligated to give anything. But what we generally tell people is what many people already do is, if someone's getting you're getting an inquiry from a prospective employer, he might give the rate of pay, the dates of employment, the title. That's all you have to give. I've had cases where the employer was set up, where the employee that was, say the employee was fired 2 years before for cocaine possession at work. Now he's turning around and he's looking for another job, and it was a setup. He had a friend or whomever call and say, "What do you think about John?" Well, the HR person said, "Oh, John was a drug addict." So now we had the second case with John. So I mean, it just turns you into, it makes you paranoid. But I mean, you are absolutely best served by keeping it, again, less is more, right? Keeping the commentary out of it and just name, rank, and serial. Stop, my dear.
How are you, Bill?
Hey, sir.
Trick question that they'll sometimes do is, would you hire the employee back?
Which employee?
If, in that scenario where the employee's gone, the new hiring manager will call you up and say, okay, if I can only verify dates and service, will you hire the employee? Would you hire the employee?
Would you answer? I wouldn't
No,
answer that.
definitely not.
No way.
So what do you answer?
What you say is, our policy is we only provide dates of employment and positions held, period. And
Okay.
you stick to that mantra.
No, I mean, we do that, and then then the other HR person says, okay, but would you hire them back?
Yeah, and that's what my answer would be.
Okay,
We
so-
only provide dates of... That's...
Any other questions?
Just number 13 on the contractor issue.
Number 13 on the contractor issue, I just wanted to get your take on that because Bob LLC looks to me like a contractor, but
Yeah, let me, and I'm going to sound so cynical with this. I've done a lot of this. For years, we got, well, it doesn't matter how we got it, but I defended the independent contractor status scores of times in New Jersey, Pennsylvania, and New York. Pennsylvania, I never lost. Every time I would get engaged to establish that the worker was an IC, I won. New York, I probably won 70% of the time. In New Jersey, I can only think of a couple times I won. And the tests are very different. In New Jersey, most times, whether you're the judge, all they care about is, they don't care how much the fact that the guy's got business cards and it comes down to, is it a bona fide, legitimate, independent business, or is he dependent upon you? Is he doing work for others, and is it real work? That's really what it comes down to. So you can talk about the IRS 20-something point test and all this other stuff. That is effective in other states, but in New Jersey, it's very, very difficult. So with this question, if you got to it, number 13, we did have in there that Bob LLC had other sources of work. But I still can't tell you for sure whether Bob LLC is going to be considered an independent contractor, because whatever we said here, either 30 hours a week he's with you, that might be viewed as he's so dependent upon you, he's not sufficiently independent. That's how tough it is in Jersey.
But I have a question. He's a we made him form corporation. If they were a corporation, they can have one company that they deal with. Does that hold? I mean,
it's helpful, but it's not alone. It's not enough, because you could turn. I mean, the classic scenario that I had was that the company relied upon 15 limousine drivers, and in 2015 they were all W-2 limousine drivers. The next year they say we're going to make all of them LLCs, and now they're ICs, but they're getting all their work from my client. Good luck. Right? All you've really done is create this fiction that now they're corporations, not individuals. It's a helpful factor when it's combined with they're paying their own insurance, they got occupational accident coverage, they got, you can line up all these things that are indicators of IC status. That's what you do to prove it. Pennsylvania, I'm going to win that. New Jersey, maybe. But you're really going to have to show that this guy has sources of work, meaningful sources of work, other than you, that he's really up and running independently.
even if he advertises.
All that stuff is helpful indicators, but I'm saying that and this is why I started off saying very cynical about this. They just cut to the quick and say, is he dependent upon you, or isn't he? And it's very tough. They want those tax dollars. Any other questions?
And ultimately, it's not that really worth it, right? I mean, just paying that stuff into it's not costing you that much typically,
If you're
right?
a limousine company and you want to avoid workers' comp,
Right.
it's huge. Or, typically, everything's generally fine until the guy gets hurt, or you decide, we don't want Bob anymore. Or, we're replacing the crazy question, how Bernie Madoff's coming in, Bob, you're out. Now Bob says, I'm going on unemployment. Bob shouldn't be thinking unemployment if he was an IC, so the question of his IC status is the threshold question in that unemployment matter. If we win that he's an IC, he has no unemployment case and it's over.
Right, I was more thinking of like the Bob LLC guy just he doesn't have a high workers' comp, and you have the exposure to, if now he doesn't pay his taxes, you could be on the hook for that as well, right? So there's just, I think the exposure versus the risk in an employee like this, especially if it works for you 30 hours a week, seems like a silly one to do, right?
Yes, I agree. Any other questions, anybody?
Anybody want to apply business?
I just saw that there fewer questions down there. It was something about recordings in the workplace, and one of them was like if somebody is recording a tirade or somebody's recording somebody without them knowing, how admissible is that?
Yeah, we should have gone to that. There's actually two of them that are about recordings. The first one, and this is, we have, it's an exaggeration to say we have an office full of these, but I have a number of active litigations where the plaintiff is backing up her allegations, by having recorded. In New Jersey, this is not the case everywhere. New Jersey is what's referred to as a one-party consent state. So as long as, which makes it not only legal, it makes it admissible for the employee to record a conversation with the boss. So and as long as the employee is a party to that conversation, be it a phone call or a meeting, that otherwise that secret recording can be used against the employer. It doesn't mean you can leave a recording device, in an office and leave. But if you're a party to it, away you go. And with the iPhones now, it is becoming really common. And that's why I very often say when I'm meeting a defendant, a supervisor who's accused of saying dumb things, and I say to him, I need you to be completely paranoid and honest with me. Let's assume everything you ever said to her over the last X number of months or years has been recorded. Let's assume it is. You start getting honesty real fast when they flush out what you might have said.
So if you're having a meeting with that employee, can you legally say to them, I want to see that your phone is off before we have this discussion? Okay.
Absolutely. There's another one about the
video recording.
Floor and the video floor.
Right. The National Labor Relations Board has now taken the position that an employer cannot have a blanket prohibition on the use of video recording at work. A lot of employers do that because they don't want their intellectual property to be videotaped or things, like that, or the tirade. But I believe it was Whole Foods had a blanket prohibition against using a video recorder at work. Obviously, everybody's cell phones have video recording capabilities on them. A few weeks ago, the National Labor Relations Board came down with a decision, and as Bill said before, you don't have to be a union employer for this National Labor Relations Act to apply to you. So their decision was that employees have the right, because of their to protect their terms and conditions of employment. So if they want to record something that they believe is a potential safety violation, they have the right to use their cell phone. So in the scenario we put in the quiz, if you see somebody going like this around the factory floor and you're saying, hey, we have a rule against doing that, okay, because you're protecting your intellectual property, the National Labor, and you say you're fired, you violated the rule, the National Labor Relations Board may say, sorry, you got to reinstate them. They were concerned that outlet was not high enough off the floor.
What if your rule is to not have phones?
Yeah, no, absolutely. Yeah, that is a legitimate rule to have. You can ban cell phones from being on or on somebody's possession, but good luck enforcing it. Because that's the problem. I mean, you're not going to stop and frisk, and oh yeah, that's a totally different seminar. Okay, so, but anyway, that's my instinct too, is just say, you leave your cell phone in the car, but then you have legitimate things, my kids need to text me when they get home, off the bus, or things like that you really don't want to, keep your employees from being able to feel comfortable with.
Just a quick follow-up on the New Jersey one-party consent state. Does it work the other way around, where if you are having a conversation with your employee, you can record it?
Absolutely.
Okay.
You got to be careful. If you have more than one location in another state, say, you really have to be careful that say they're dialing in on a video conference from California.
Yep.
From California, that would be illegal. So that's a two-part. So you have to know where the person is where they're calling or from a two-party or one-party consent state. Anything else? Well, thank you. One more.
Do you have a copy of this with all the answers and the logic behind it?
As we go along. Yeah, I'll get it to you. But thank you all very much.
There's one more in the back. Yeah.
Bill, sorry, just one question. The number 15, the 59-year-old employee, you gave him severance, he signed a release. Is that a trick question in terms of they signed a release and it doesn't protect you?
It is a trick question. And this is a matter of what this release does not have is not the magic, but is the necessary language that needs to be there anytime you're getting a release or you have a separation agreement with an employee over age 40. This comes from, you may have seen this language, it comes from the Older Workers Benefits Protection Act, which you have to spell out in the agreement for it to be enforceable, that you have 21 days to review, 7 days to retract, encourage you to see a lawyer. You'll typically see those things in the boilerplate language of any separation agreement. So if you mistakenly give this guy whatever you gave him here, you gave him severance 1 month and you gave him a general release and it did not have that Older Workers Benefits Act language, you've just given him money and he can turn around and sue you and no court's going to enforce that release.
Well, that was uplifting, wasn't it?
All right. Thanks very much, everybody. Appreciate it.
Thank you.
I want to thank everyone for coming out today. You've received a tremendous amount of valuable and timely information, so now it is up to you to implement these great ideas and concepts that Mark and Bill have shared with us. Mark, Bill, and I will be here for a little bit longer. Our business cards are outside on the table, and your sponsors today are Cowan, Gunteski Co. and Kluger Healey. Thank you.